from the Constitution that advance that objective must be interpreted harmoniously with the Constitution. My Lord, the standing orders are enacted pursuant to Article 124 of the Constitution. As you have demonstrated, the Constitution contemplates that impeachment proceedings must be undertaken expeditiously. So when the standing orders provide for an expeditious manner in which an impeachment process ought to be undertaken, then they cannot surely be declared unconstitutional. And my Lord, we make reference to a decision of this Honorable Court in Baraka Isa Kombo versus the Independent Electoral and Boundaries Commission. The same decision appears at volume 2 of our digest of authorities, specifically page 714. In that case, this court held as follows. If timelines in determination of electoral dispute is a norm and principle of the Constitution, then all the rules that further such norms and principles are themselves derivatives of the constitutional ethos and must, as of necessity, be complied with to the letter. We have also referred this Honorable Court to another decision which appears at page 729 of the same digest of authorities, that is volume 2. That is Biosystems Consultant versus Nearly Links Arcade. It's a 2023 decision where this court found that the constitutional timelines are cast in stone. The decisions over time have crystallized this. The matter is mainly, the Supreme Court and the Court of Appeal have dealt with various constitutional timelines and for good measure found their inflexibility. So, my Lord, based on those authorities and our submissions, we pray that this Honorable Court finds against the petitioners in relation to the allegation that Standing Order number 64 of the National Assembly Standing Orders is unconstitutional. And my Lords and my Lady, just to contradistinguish with other instances in the Constitution, Article 105 of the Constitution provides that when there is an election petition stemming from an election of a member of Parliament, such a petition must be heard and determined within 6 months from the date of filing. The Constitution does not provide for timelines for hearing of petitions from decisions, from elections of members of the County Assembly. But when you look at Section 75 of the Elections Act, it provides, similar to the Constitution, that in elections relating to members of the County Assembly, courts must hear and determine those petitions within 6 months. So we cannot really argue that the Elections Act is unconstitutional, providing the same timeline as the Constitution, just because they now relate to members of the County Assembly and not to members of Parliament. My Lords, now I'll proceed to the second issue as to whether the National Assembly was not properly constituted to hear and determine or approve the impeachment motion of the first petitioner for failure to adhere to the 2/3 gender rule under the Constitution. Our first submission on that particular point, my Lord and my Lady, is that we note to point out to this Honorable Court that this particular question is pending before a 5-judge bench of this court. In the case of Milimani High Court petition number E291 of 2020, Lena Conchela and another versus Honorable Justice David Kenani Maraga and others. There are several petitions which have been consolidated under that particular petition. My Lord, this petition having been filed before the instant petitions, having been filed in 2020, it's a 2020 ongoing matter, this court ought to stay a decision on this matter on the basis that it is a matter which is sub judice. But my lords, without prejudice to that argument, we need to highlight some points before this court in the event this court goes on and makes a determination on this particular issue. The first, my lord, is our submission. It is our submission that the Parliament is actually properly constituted. And my lord, we say so based on a reading of the Constitution. My lords and my lady, in relation to the question of the Constitution of Parliament, the same has been expressly stated in the Constitution. Article 97 states, in fact, it reads Part 2, composition and membership of Parliament. And then Article 97 states, membership of the National Assembly. The National Assembly consists of, and it lists members of the National Assembly, 290 members, each elected by the registered voters in a single-member constituencies, 47 women representatives, 12 members who are nominated by parliamentary political parties, and the Speaker, who is an ex-officio member. Once Parliament has fulfilled that mandate, my lords and my lady, we cannot then argue that Parliament has not been properly constituted. But my lord, the question that begs is what then is the position of Article 81B of the Constitution, which the petitioners have referred this court to. Article 81B states that not more than 2/3 of members of elective public bodies, including Parliament, shall be of the same gender. Article 27(8) then says that Parliament shall enact legislation to fulfill that requirement. It is common ground, my lords and my lady, that Parliament is yet to enact that particular legislation. But it is also a submission that failure to enact that legislation does not render Parliament to be properly constituted. And the reason we make this submission is based on a decision by the Supreme Court, which you have provided before this Honorable Court in the second and seventh respondents supplementary list and band of authorities. My lord, when confronted with this issue, the Supreme Court in Advisory Opinion number 2 of 2012, which my lord, I must say some of the members before the court were before the bench at the time, had this to say at paragraph 74. That as Article 81B of the Constitution, standing as a general principle, it cannot replace the specific provisions of Article 97 and 98 of the Constitution, not having ripened into a specific enforceable right as far as the composition of the National Assembly and the Senate are concerned. That's the Supreme Court. The Supreme Court, under paragraph 64 of the said decision, also states as follows. We are concerned by the fact that none of the council who urged the immediate enforcement of the gender equity rule devoted their attention to the inherently different parts of enforcement for a specific accrued right on one hand and a broad protective principle on the other. It is clear to us that Article 81 of the Constitution bears the heading General Principles of Electoral System. The Supreme Court, my lords, went on to say that unless and until Parliament enact legislation, it could not be expected to comply with Article 81 of the Constitution, but its composition will remain valid. But my lord, even if the court was to find that the Parliament is not properly composed or constituted, it is our submission that the prayers made by the petitioners on this particular issue could not issue, because the Constitution itself guides the court as to the type of order it can make when it finds that Parliament has not been properly constituted. Under Article 261 of the Constitution, my lords and my lady, the Constitution says that when a petitioner approaches this honorable court seeking a declaration that Parliament has not been properly constituted, the court will make a declaratory order and shall direct Parliament to comply within a specified period of time. That is the order that this court can give. After issuing that order, and Parliament failing to comply with such an order, then, my lords and my lady, the next step is for the Chief Justice to advise the President to dissolve Parliament. The wording of Article 261 of the Constitution is very critical because it is forward-looking. The Constitution does not state that improper constitution of Parliament annuls the acts of Parliament going backwards. It is after the President has dissolved Parliament, upon advice by the Chief Justice, that we then get into a situation where all subsequent acts of Parliament will be deemed nullified until a new Parliament comes into place. And my lord, this is important because the first petitioner, having been impeached by the National Assembly and subsequently the impeachment having been upheld by the Senate, such an act cannot be reversed because the Constitution only contemplates dissolution of Parliament going forward. But equally importantly, my lords, it is our submission that when that act is done and a new Parliament comes into force, the provisions of Article 261 starts running afresh. In this particular matter, my lord, once the 13th Parliament was elected into office, we have not had an instance where this court has made an order declaring Parliament not to be properly constituted, and the same having been forwarded to Parliament, and Parliament failing to comply, and the Chief Justice advising the President, and the President dissolving Parliament. Those steps under Article 261 of the Constitution have not crystallized. On this basis, my lords and my lady, it is a humble submission that the petitioner's prayer, to the extent that they seek a finding that Parliament was not properly constituted at the time it deliberated over and made a resolution to impeach the first petitioner, cannot issue. Unless the bench has questions for me, I thank you for this opportunity.
My lady, my lords, my name is Kipkogei, appearing for the National Assembly, and I shall be addressing you on the question of public participation before the National Assembly. I shall also briefly touch on the authorities which was submitted by my learned friend, Mr. Sakimpa, and Mr. Kibemungai. Briefly. To start with, my lord, I shall address you on public participation in three perspectives. The first perspective is the question of thresholds. The second perspective is how the National Assembly applied that constitutional value. And lastly, I shall address the various questions which have been raised by the various petitioners. And I think this is one issue which cuts through all the petitions, with the exception of the petition filed by my good friend Tess from Kerugoya. My lords, my lady, the Constitution in Article 118 requires Parliament, and Parliament here is the two houses, the National Assembly and the Senate, to facilitate public participation in lawmaking and its processes. The key word used in that article, my lords, my lady, is facilitate. It imposes on Parliament to facilitate public participation and involvement of the public in undertaking its business and in its committees. That is important, my lord, because the manner in which the petitioners have couched their petitions before you is to create the impression that Parliament is compelled to ensure mass attendance by the members of the public to public participation fora, to obtain certain numerical numbers, and such like. It is the responsibility of Parliament in Article 118 is to facilitate public participation. And this, my lord, was interpreted by the Supreme Court in Supreme Court petition number, it is, the correct citation is Cabinet Secretary for the National Treasury and Planning and 4 others versus Okoiti and 52 others. And at page 143 of that decision, the court said, Article 118.1 only imposes a duty to facilitate public participation and involvement in legislative processes, and therefore cannot be basis for the argument that the National Assembly is under an obligation to provide reasons or for accepting or rejecting views. And the same court quoted the South African decision in Mogale versus Speaker of the National Assembly, where the court defined what Parliament is required to ask itself. And it posed like this. What Parliament itself, the first rubric is A, what Parliament itself has determined is reasonable, and how it has decided it will facilitate public involvement. B, the importance of the legislation or the process being undertaken and its impact on the public. And C, time constraints on the passage of the particular bill and the potential expense. Those are the key guiding factors which the Supreme Court identified when it cited the Mogale decision. Crucially, my lords, my lady, at paragraph 88 of the same decision, imposed an obligation on persons who are challenging public participation. And it found, my lords, my lady, that allegations of lack of public participation does not automatically vitiate the process. The allegations must be considered within the circumstances of each case, the mode, the degree, the scope, and the extent of public participation, and it is to be determined on a case-to-case basis. So, my lord, the responsibility of Parliament is to open the door. To open the door for citizens to engage it in that particular, whichever undertaking Parliament may be dealing with. It is not to drag citizens through that door. Once Parliament has provided a platform, it is the civic duty of every citizen to utilize that opportunity and engage Parliament for purposes of these proceedings, the National Assembly. So that, my Lord, it is immaterial the number of Kenyans who have submitted views on any particular subject. What is material is whether the National Assembly afforded a reasonable opportunity for every Kenyan to submit those views. That again was highlighted by the Supreme Court. So that, my Lord, when my learned friend, Mr. Tom Macharia, my very good friend, argues that 200,000 Kenyans submitted views and ascribes a percentage as against the entire population of this country, it's our submission, my Lord, that he misses the point by a mile. The second aspect of principle which we would wish to address you on, my Lord, is the question as to why public participation? What is the import? What is the purpose of public participation? And I can do no more, my Lord, than to agree with Senior Counsel Professor Githu Muigai when he made the case that the role of the public is to influence the process. They do not vote. They assist those who will vote to make the decision. In the particular case we are dealing with, my lords, my lady, and on an important vote such as impeachment of a deputy president, it is some sort of an instruction by the members of the public, those who elected the MPs, on what they think about that particular motion. But at the end of the day, it is the particular members of Parliament who will take the decision on which direction to vote. And that is the character and the nature of representative democracy. That is the expectation and the anticipation of our Constitution. The Supreme Court, in the same decision, at paragraph 84 of their decision, state, my lord, my lady, that the constitutional framework acknowledges that while complexities of a modern state require decision-making by representatives, these processes must involve meaningful public participation to achieve democratic legitimacy. These two facets of our democracy should not be seen as conflicting with each other, but as complementary. And they proceed in paragraph 83. They cite the decision of the Court of Appeal in Fevan's case. My lord, all those are in our authorities. I need not regurgitate before you. The third element, the third issue of principle which I wish to address you on is that with respect to impeachment proceedings, these were time-bound proceedings. And public participation with respect to impeachment proceedings must be taken within the context of the time available to whichever organ of the legislative assemblies which is dealing with that matter. And any analysis on adequacy of public participation must be measured against the time available for the particular house as it rendered its determination. Again, the decision of the Supreme Court in Okoiti, it's popularly known as the Finance Bill decision, at paragraph 125, the Supreme Court states that timelines, whether statutory or constitutional, and the cost implications, the mode and the approach to public participation should be taken into account in deciding whether Parliament has complied with its duty to facilitate public participation. Therefore, where evidence is proffered demonstrating that Parliament was required to pass a bill within a specified period of time, This factor will be accorded weight in determining the reasonableness of the measures put in place to facilitate public participation. As I submitted, my lord, my lady, impeachment proceedings were time-bound. The adequacy or otherwise of the public participation which was undertaken has to be measured against the time available to the National Assembly. Similar sentiments were expressed by the Supreme Court in paragraph 127 of that same decision. I shall now address you on how the National Assembly went about conducting public participation for purposes of the impeachment proceedings against the first petitioner. And I would start by saying the record speaks for itself. We've submitted an affidavit which contains lengthy material which was demonstrating public participation undertaken by the National Assembly. And I will highlight a few of the channels which the National Assembly utilized to reach as many Kenyans as they could possibly do. Number one, my lords, my lady, notices were published in the mainstream dailies in both English and Kiswahili. And that was on 2nd, 3rd, and 4th of October 2024. I would refer my lords to Annex SN5, running on pages 225 to 234 of the affidavit of Samuel Njoroge. In the same affidavit, my lord, my lady, it's averred that notices were broadcast on mainstream TV channels, radio stations, and on Parliament's official website, together with its social media handles, X, Facebook, TikTok, Instagram. Again, this is in Annex SN7 of the affidavit of Samuel Njoroge. My lord, there were public hearings initially held at every county headquarters where members of the public were invited to engage staff of the National Assembly and submit their views through templates which were provided to them. It's important, my lord, to point out that the grounds upon which the first respondent was to be impeached on was set out not only in those templates, but also in the publication I adverted to earlier. Again, my lord, my lady, those are attached. And then, my lord, there were public hearings on 4th and 5th of October 2024 in every county headquarters. There was an order issued by His Lordship Justice Mwongo in petition E014, and I believe it's one of the petitions you shall be determining it, my lord. An interlocutory order was issued directing the National Assembly to expand the scope of public participation to constituencies. And that was done, my lord. So effectively, my lord, public participation was also undertaken in all the 290 constituencies in the country. My lord, Parliament also provided a dedicated email address from which members of the public who are unable to submit their views in physically could send their views to Parliament. But at the end of the day, my lord, all this material, all the views which have been collected by the National Assembly through its staff, it was to the benefit of the members of Parliament who are going to take the vote. It has not been suggested, none of the petitioners before you have suggested that any of the members of the National Assembly was unable to vote because they were not duly instructed by their constituents. There is none. If anything, only one MP of those who were able to vote abstained from voting. In other words, the members of Parliament were able to make choices based on the views they had gathered from the members of the public. My Lord, what was the outcome of the public participation exercise which was undertaken? Some 223,000 Kenyans submitted their views physically in the various offices of Parliament. Probably the most intense and elaborate public participation exercise ever undertaken in this country. I think it mirrors the public participation which was undertaken prior to the adoption of the Constitution. I think that is the only other public participation session which rivals the adoption of the new Constitution. My Lord, views were received on email, others were received on the X handle of Parliament, and it was effectively utilized by the members. It has been suggested in one of the petitions that the format which was developed by staff of Parliament for collection of views was restrictive, that probably it should have been an empty page for Kenyans to write their views on. It's our submission that, my Lord, it was more about accessibility, enabling Kenyans to digest the grounds and express their views. But any other Kenyan who felt that they needed to submit their views in a different format, and that's why the formats which were utilized differed in nature and character, they were at liberty to do so, and many did so. There were affidavits submitted, there were memoranda submitted, so there was no restriction to utilize that form. And the challenge on that ground, my Lord, is without basis, and it is for rejection, and we urge you to reject. It did not restrict any Kenyan to that particular mode. My Lord, allow me to then go to the third limb of the public participation by responding to some of the allegations which have been raised. But before I do so, allow me to submit and say, in terms of quality and the quantity, the National Assembly met the threshold expected of it in the Constitution, Article 10, Article 118, and also by the established jurisprudence of this Court, Court of Appeal, and the Supreme Court. The test required by all the existing jurisprudence has been satisfied and was satisfied. Now, to respond to the issues which have emerged or have been raised by some of the petitioners, it was alleged, and I believe this was alleged or raised by the third petitioner, the Honorable Njeri, that there were allegations of violence, intimidation, and disorganization in the public participation forum. It is our submission, my Lord, that with the exception of Kirinyaga County, and in particular Kerugoya Township, the National Assembly did not experience any issues of violence, intimidation, or disorganization. And why is Kerugoya important, my Lord? The third petitioner, and I believe in her petition she identifies herself as the women rep, the county woman member to the National Assembly for that particular county. The county office in that particular county was closed by herself, by the third petitioner. She closed her office and then rushed to court that same day to obtain orders before Justice Mwongo. And she did obtain those orders, but it prompted action from the National Assembly. And in our annexure SN10, we have attached a letter from the clerk of the National Assembly addressed to her, raising concerns with our poor attempt
must be somewhere in there whether she began ourselves against this court, so that council and lordship may direct us to the affidavit that is currently highlighted that specifies that Honorable Jerry closed the platform where public participation was supposed to take place. The council can guide us on the particular paragraph of that one.
My Lord, I shall retrieve, I'll ask my colleague, Mr. Oma, to retrieve the affidavit. But there is an annexure to that affidavit, a letter from the clerk of the National Assembly addressed to her, raising concerns about why she closed the office and locked out members of the public from submitting their views. It was not a personal office. This is a public office paid by the National Assembly. There was no basis for her to close it. That letter, my Lord, is available, and I'm surprised and shocked that my learned friend has not gone through it. Probably that's why these petitions are being filed on elementary questions, which are proven. My Lord, the material is there. If I could go on, then I'll actually read for the court the entire text of the letter. It's 2 pages. So that, my Lord, the conduct of the third petitioner, a supplicant before you, a person praying and seeking relief from this court, is that of reminiscent of an arsonist who starts off a fire, then runs to the police station to accuse people of starting off those fires, or seeks to be appreciated for putting off a fire they started. My Lord, save for that particular incident in Kirinyaga County, the entire country was peaceful. And my Lord, may I put it on record also that subsequently, on the second day, after his lordship had granted had directed the National Assembly to cascade the public participation to constituencies, public participation did take place in all the constituencies in Kirinyaga County. So those allegations, my Lord, have no basis. My Lord, I've accessed the material which my learned friend Mr. Njiru was demanding. And I'm surprised, my Lord, because I was in court in this matter with Mr. Njiru. And there was palpable tension in Kirinyaga town. In fact, we had to be escorted by police to access Kirinyaga town on the day petition number 14 was coming up. Courtesy of the violence meted on the people of Kirinyaga by the third petition. I can state that from the back. But if my learned friend requires any evidence, then it is in paragraph 54. paragraph 53 and paragraph 54 of the petition.
The objection I'm raising is raising allegations that the violence were initiated by the women rep, which allegations are not substantiated, and therefore we are opposed to that kind of submission.
Let's see if we have anywhere in the line of justice.
I can supply to the court, Madam.
Paragraph 54.
I will, Madam. In paragraph 53, my lord, the deponent, the clerk of the National Assembly, states, it is important to note that in further compliance with the orders issued in Kerugoya, petition number this, Honorable Jane Jerry Minor versus the Senate, National Assembly, and others, my office efforts to contact Honorable Jane Jerry Minor's county office to inquire why the Kirinyaga County Women Reps office was closed during the public participation exercise. Despite parliamentary officers being deployed to assist the office staff informed parliamentary officers that the closure was directed by the petitioner. This assertion has been on record since, I think, 6th of October last year, because we attended to the matter with Mr. Degwanjeru, and I filed an affidavit in that matter, and this assertion is there. It's not been denied. Further, my lord, we've attached the letter which was authored to that office by the clerk of the National Assembly. It's SN3, 3 pages. Do I read it, my lord?
I believe the paragraph that Council is referring to does not associate the Honorable Jane Minor with the violence that Council is submitting on. So my Lord, Council is restrained from testifying from the bar.
Paragraph 54, my lord, it states, the staff indicated that Honorable Jane Jerry Minor had ordered the closure because she opposed the special motion. Because she opposed the special motion for removal of the Deputy President, an action seemingly intended to frustrate the public participation exercise. What more do I need to say? Do you want to? I can avail to the court or to my learned friend. So, my lord, public participation was effective with the exception of those challenges brought by certain individuals. But it is important to also note, my lord, that the Constitution does not demand a flawless process. It just demands that the people be given a meaningful opportunity to participate. And this, we say, my lord, the National Assembly did. If it was an exam, it would be an A. We've spent a considerable proportion of our written submissions, my lord, on that subject. I think it's from page 52 of our submissions to page 69. We would ask, my lords, to go through those written submissions, because they address much more than I've been able to capture within the limited time available. My lord, the second issue which has been raised in the petitions is that the National Assembly should have circulated the Deputy President's response as it undertook the public participation exercise. There is a challenge by the first petitioner that his response to the issues which are being raised in the special motion should have been circulated together with the public participation template. My lord, it's our submission that considering the constitutional architecture of how impeachments are processed, that proposition from the first petitioner is not only untenable, but has not complied with the way impeachment proceedings are structured in our Constitution. I think my learned friend, Mr. Gumba, has taken you through the process through which impeachment motions are processed. It starts with a motion supported by a third. If it is not supported by a third, it doesn't become a motion. It's not even tabled in the House. So there is no opportunity at that point in time to ask the person who sought to be removed from office to give his views on the motion. Once the motion is well supported, it is tabled on the floor of the House. And subsequently, probably a committee of the House would be assigned to a committee to go through it. My Lord, those processes, until such time that Parliament intends to vote, the National Assembly intends to vote on whether to approve it for trial by the Senate, there is no room for the views of the person sought to be impeached. And in this particular case, he was heard prior to the motion being voted on. And that is the procedure anticipated by both the Constitution and the standing orders of the National Assembly. It has also been alleged, my Lord, I believe this is from the third petitioner, that the public participation report was fabricated or that it is cosmetic. They've thrown in quite some adjectives there. It's our submission, my Lord, that those allegations are not supported by evidence. The public participation report is a product of the House, of the National Assembly. It is in the answer of the National Assembly. It was considered by members of the National Assembly. It is authoritative, it's verifiable, and is accessible. So it's not cosmetic, it's not fabricated. It was developed by the staff of Parliament based on the material they collected across the country. May I say, my Lord, that public participation report has been produced by the clerk of the National Assembly to this court, together with the answer showing its adoption, and it has not been challenged, other than through the submissions which were made by my learned friend, Mr. Muge. The Supreme Court in the Institute for Social Accountability and Another versus the National Assembly has affirmed that courts ought to take judicial notice of answered records as accurate reflections of parliamentary business. And this is not a forum to assert, especially for the third petitioner, because that allegation is also coming from the third petitioner. If they had a problem with the answered and the record of the National Assembly, especially herself being an MP, she had reasonable opportunities to raise it with Parliament. Besides, she should have denied it. It has also been alleged, and I should leave this to the Senate, that the Senate had a duty to also undertake independent public participation without prejudicing the submissions which will be made by teacher Professor Gender. It is our submission that the Senate is a trial chamber. It is not, the Senate has when considering an impeachment motion, sit as jurors. They try the facts, they test the evidence, and consequently, as a trial of fact, they are not to be influenced by anything else other than the facts placed before them. In this case, by the National Assembly and the Deputy President. So that, my Lord, there is no duty to undertake public participation in the Senate. Allow me to address you on the last limp on public participation, touching on the National Assembly, and this is with respect to the appointment and approval of Professor Kindiki as Deputy President. My Lord, this was adverted to by Senior Counsel Professor Githu Muigai on the responsibility of the various actors when it comes to approval, nomination and approval of a Deputy President candidate. Article 149, my Lord, of the Constitution provides that within 14 days after a vacancy in the office of the Deputy President arises, the President shall nominate a person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. It's our submission, my lords, my lady, that a contextual reading of Article 149 and a textual reading as well yields to the irresistible conclusion that when it comes to nominations, it is the President to nominate. It permits of no other interpretation. And the duty of the National Assembly is to vote on the nominee. And because they are required to vote on the nominee, it's our submission, my Lord, that contrary to the assertions which has been raised in some of the petitions, that there was a requirement for public participation, it's our submission that on that particular process of processing the nominee to the office of Deputy President, there was no requirement for public participation. Allow me then, my Lord, I rest on the arguments in relation to public participation at the various stages. I would only refer my Lords, my Lady, to our written submissions for their full effect and intent. Allow me, my Lord, to then address you briefly on the authorities which have been submitted by my learned friends for the petitioners, especially the decisions coming from South Africa. My Lord, I begin by submitting that with respect to those decisions, the Constitution of South Africa and that of Kenya are not in pari materia with each other. Those two decisions, probably three decisions, EFF1, EFF2, EFF3, were rendered by the the Constitutional Court of South Africa. When you look at the Constitution of South Africa, in Article 167, they call their sections, Section 167 of the Constitution, of their Constitution, 167(4)(e), with respect to the powers of the Constitutional Court. One of the powers conferred on that court is to determine whether Parliament or the President has failed to fulfill a constitutional obligation. It's a power conferred directly to inquire into the conduct of Parliament or the President and to assess whether they have failed to fulfill a constitutional obligation. And that constitutional scholars have written about it on the place of the Constitutional Court of South Africa in their democracy. So much so that the Constitutional Court of South Africa sits probably higher than the organs created in the Constitution, because it is enabled to question in a more elaborate way the affairs of all state organs. So what happened in EFF 2 and the proper citation of that decision is Constitutional Court Case number 76 of 2017, Economic Freedom Fighters as the first applicant and 4 others, and 3 others, together with Democratic Alliance as an intervening party, against the Speaker of the National Assembly and President Jacob Zuma. My Lord, in that decision, the EFF, which is a political party in South Africa, had sued Parliament for failing to implement the decision of a constitutional commission known as the Public Protector, which had established that President Jacob Zuma had helped himself to public funds, which he used to renovate his house in his rural home. And the Public Protector had directed that the president should pay back that money. Now, he didn't pay back. And the question became whether the National Assembly should have him impeached under Section 80, I believe, is it 85 or 89 of their Constitution. Of course, the National Assembly, being dominated by members of the president's political party, did not vote to impeach the president. And EFF, another political party, went to court in these proceedings. They had gone to court in different proceedings, earlier proceedings. They faced a challenge, that was EFF 1. In EFF 2, the Constitutional Court directed Parliament, the National Assembly, to set up rules of procedure which would enable the processing of impeachment motions, because there was a challenge as to which committee is to process that motion. My Lord, they did make those rules, and they were used in EFF 3, but I'll get there. But the concern which the petitioners before you raise now is that the reason why the Constitutional Court directed Parliament to make rules is because there was no opportunity for an inquiry to be undertaken. And the majority in that decision felt that it is wrong for members of the National Assembly to simply vote on a motion without anyone processing whether the grounds and the facts, the facts which have been laid can establish a ground for removal. So they said you must then have an inquiry panel or a committee, an impeachment committee. This is what they stated then at page 62 of that decision. You will have an opportunity, my lords, to look at it. But they said that it is then important for an inquiry process to be undertaken to tie up the facts with the grounds which are in the Constitution. My Lord, in Kenya, we have a Senate which does exactly that which is problematic in down South Africa. We have a Senate which undertakes the inquiry. So this decision, to the extent that it is being used for purposes of laying a basis for taking the impeachment proceedings to a committee, is not useful. It's not useful for the petitioners. But it is useful for other purposes. It's useful for the National Assembly. You notice, my Lord, that the Constitutional Court of South Africa is asserting that the values contained in their constitution must be, and that is why they are forcing their National Assembly to enact rules, to create procedures for processing. Why? Because they are saying if someone has helped themselves to public funds, they must be held to account. And this decision is about accountability by those in public office. Now they are asking you, my Lord, to do the opposite, to protect them from accountability. That's what they want, to use this decision to jettison parliamentary proceedings, which where our own National Assembly has held a deputy president to account. Yeah, the South African National Assembly did not hold theirs to account. the Constitutional Court intervened. They're asking you to do the opposite. Don't do that, my lords. Don't. You will be doing the opposite of what the South African court has done. Now, it becomes more poignant, my lord, when it comes to EFF3, the decision which was rendered last Friday. Again, almost similar facts. President Ramaphosa helps himself to sources some money from somewhere. It's in foreign currency. He doesn't declare it. And some thieves go to his house. They steal it. He is stuck. How can you report to the police? Money is foreign currency, which you have not declared. He causes his security officers, personal security, presidential guards, to go and look for those fellas. Makes a call to the president of Namibia. Says, one of my citizens is in your country with my money. Long story short, it is investigated. It is found that he had not reported that incident to the nearest police station in breach of their constitution. EFF goes to court and says, at least this time around, this is now case number 35 of 2024. Between 2017 and 2024, National Assembly established rules, establishing a panel of inquiry and an impeachment committee within the standing orders of their assembly. So a panel of inquiry investigates, finds the president culpable, a report is tabled. ANC uses its majority to jettison the report. Now the Constitutional Court is saying, no, you cannot jettison this report before it is tabled, before the panel of inquiry. Again, they are seeking to hold the president to account. Now, the petitioners before you today are asking you to use this authority so that a person who has already been held to account can escape. Don't do that. Stand with your counterparts in South Africa. Hold public officials to account. My lord, they spent 12 hours to make submissions before you. Not once, and I tried to listen, not once did they mention the word accountability, yet it's a value in Article 10. Not once did they mention the word equity, it's a value in Article 10. Not once did they mention the word inclusiveness, it's a value. To them, the only value they mention time and time again is public participation. Please, I would ask you, my lord, look at all those values, because the impeachment motion which was before you was enforcing those other values they don't care to mention. I rest, my lord.
Yes, if it pleases you, my lords, I will go first. I will address the court for about 1.5 hours max, and then my learned friend, Mr. Mukele Moni, will go after me, and then Mercy Thanji will conclude by analyzing or submitting on case law and responding on various legal questions. I will try my law.